In this section, we discussed some important acts or bills. First one, Mines and Minerals Amendment Act 2021. Mines and Minerals Development and Regulation Amendment Act 2021 amends the Mines and Minerals Act 1957. Highlights: removal of restriction on and use of minerals. The Act provides that no mine will be reserved for particular end use. Sale of minerals by captive mines. The Act provides that captive mines may sell up to 50% of their annual mineral production in the open market after meeting their own needs. The central government may increase this threshold through a notification occasioned by the central government in certain cases. The Act empowers the central government to specify a time period for completion of the occasion process in consultation with the state government. If the state government is unable to complete the occasion process within this period, the occasions may be conducted by the central government. Transfer of statutory clearance. The Act provides that transferred statutory clearance will be valid throughout the lease period of the new leases. Allocation of mines with expired leases. The Act says that mines whose lease has expired may be allocated to a government company in certain cases. The state government may grant a lease for such a mine to a government company for a period of up to 10 years or until the selection of a new lease, whichever is earlier. Second one, Insurance Amendment Bill 2021. The Parliament has passed the Insurance Bill 2021. Key features of this bill. The bill amends the Insurance Act 1938 to increase the maximum foreign investment allowed in an Indian insurance company. The bill increases the limit on foreign investment in an Indian insurance company from 49% to 74% and removes restrictions on ownership and control. While control will go to foreign companies, the majority of directors and key management persons will be resident Indians who will be covered by law of the land. Background: foreign investment in the insurance sector was first permitted in the year 2000 up to 26%. Subsequently, via an Amendment Act of 2015, this limit was raised to 49% of the paid-up equity capital of such company, which is Indian owned and controlled. Third one, Places of Worship Act. A petition filed in the court challenged a special law, Places of Worship Act of 1991, which freezes the status of places of worship as it was on August 15, 1947. What are the objectives of the Act? To freeze the status of any place of worship as it exists on August 15, 1947, to provide for the maintenance of the religious character of such a place of worship as on that day. To pre-attempt new claims by any group about the past status of any place of worship and attempts to reclaim the structures or the land of which they stood. Key features. The Act declares that the religious character of a place of worship shall continue to be the same as it was on August 15, 1947. It says no person shall convert any place of worship of any religious denomination into one of a different denomination or section. It declares that all suits, appeals, or any other proceedings regarding converting the character of a place of worship which are pending before any court or authority on August 15, 1947 will abate as soon as the law comes into force. No further legal proceedings can be instituted. Exceptions. These provisions will not apply to ancient and historical monuments and archaeological sites and remains that are covered by the Ancient Monuments and Archaeological Sites and Remains Act 1948. A suit that has been finally settled or disposed of and any dispute that has been settled by the parties or conversion of any place that took place by acquiescence before the Act commenced. The Act also does not apply to the place of worship commonly referred to as Ram Janmabhoomi, Babri Masjid in Ayodhya. This law will be overriding effect over any other law in force. Fourth one, National Commission for Allied and Healthcare Professionals Bill 2021. National Commission for Allied and Healthcare Professions Bill passed by Parliament to regulate practice of allied and healthcare professionals. Key features of the bill. The bill seeks to set up a National Commission for Allied and Healthcare Professions to regulate and standardize the education and practice of allied and healthcare professionals. The functions of the proposed National Commission include framing of standards for education and practice, creating and maintaining an online central register of all registered professionals, providing basic standards of education and providing for a uniform entrance and exit examination. Under the legislation, only those enrolled in a state register or the national register as a qualified allied and healthcare practitioner would be allowed to practice as an allied and healthcare practitioner. Definitions. The bill defines an allied health professional as an associate, technician or technologist trained to support the diagnosis and treatment of any illness, disease, injury or impairment. Such as professionals should have obtained a diploma or degree under this bill. A healthcare professional includes a scientist, therapist or any other professional who studies, advises, researches, supervises or provides preventive, curative, rehabilitative, therapeutic or promotional health services. Such as professionals should have obtained a degree under this bill. Allied and healthcare professionals that are mentioned in the bill include professionals working in life sciences, trauma and burn care, surgical and anesthesia related technology, physiotherapists and nutrition sciences. Significance. The legislation will increase employment opportunities for the allied and healthcare professionals and provide dignity to their valuable works. Also, there is an immense demand for the qualified healthcare professionals and the legislation will provide necessary impetus in providing affordable healthcare to the people. Fifth one, National Food Security Act 2013. Department of Food and Public Distribution issues directions to states or UTs to include all eligible disabled persons under the National Food Security Act 2013. It has also asked the states to ensure that they get their entitled quota of food grains under NFSA or Pradhana Mantri Garib Kalyan Anna Yojana. Enabling provisions. Section 38 of the Act mandates that the central government may from time to time give directions to the state governments for effective implementation of the provisions of the Act. The Section 10 of the National Food Security Act 2013 provides for coverage of persons under the Antyodaya Anna Yojana in accordance with the guidelines applicable to this said scheme and the remaining households as priority households in accordance with such guidelines as the state's government may specify. Disability is one of the criteria for inclusion of beneficiaries under AAY households. National Food Security Act NFSA 2013. The objective is to provide for food and nutritional security in human life cycle approach by ensuring access to adequate quantity of quality food at affordable prices to people to live a life with dignity. Key features. Coverage and entitlement under Targeted Public Distribution Systems (TPDS). The TDPS covers 50% of the urban population and 75% of the rural population with uniform entitlement of 5 kg of food grains per person per month. However, the poorest of the poor households will continue to receive 35 kg of food grains per household per month under Antyodaya Anna Yojana. Subsidized prices under TPDS and their revision. For a period of 3 years from the date of commencement of the Act, food grains under TPDS will be made available at subsidized prices of Rs 3/2/1 per kg of rice, wheat and coarse grains. Identification of households. The identification of eligible households is to be done by states or UTs under TDPS determined for each state. Nutritional support to women and children. Children in the age group of 6 months to 14 years and pregnant women and lactating mothers will be entitled to meals as per prescribed nutritional norms under Integrated Child Development Services and midday meal schemes. Malnourished children up to the age of 6 have been prescribed for higher nutritional norms. Maternity benefit. Pregnant women and lactating mothers will also be receiving maternity benefit of Rs 6,000. Women empowerment. For the purpose of issuing of ration cards, eldest woman of the household of age 18 years or above is to be the head of the household. Grievance redressal mechanism. Grievance redressal mechanism available at the district and state levels. Cost of transportation and handling of food grains and fair price shops, dealers' margin. The expenditure incurred by the state on transportation of food grains within the state, its handling and FPS dealers' margin as per norms to be devised for this purpose, and assistance to states will be provided by the central government to meet the above expenditure. Transparency and accountability. In order to ensure transparency and accountability, provisions have been made for disclosure of records relating to PDS, social audits, and setting up of vigilance committees. Food security allowance. In case of non-supply of entitled food grains or meals, there is a provision for food security allowances to entitled beneficiaries. Penalty. If the public servant or authority fails to comply with the relief recommended by the district grievance redressal officer, penalty will be imposed by the State Food Commission according to the provision. Sixth one, Essential Services Maintenance Act. The Essential Service Maintenance Act is an act of Parliament of India. Objective: it was established to ensure the delivery of certain services which, if obstructed, would affect the normal life of the people. This includes services like public transport, health services. ESMA gives police right to arrest without a warrant anybody violating the Act's provisions. Implementation. The ESMA is a law made by the Parliament of India under list number 33 in concurrent list of 7th schedule of Constitution of India. Although it is a very powerful law, its executions rest entirely on the discretion of the state government. Each state in the Union of India has a separate State Essential Services Maintenance Act with slight variations from the central law in its provisions. This freedom is accorded by the central law itself. Seventh one, the Scheduled Tribes and Other Forest Dwellers Recognition of Forest Rights Act 2006. Review petition of over 1,000 tribals from Mysore district, Karnataka for recognition of their claims over forest land under the Scheduled Tribes and Other Forest Dwellers Act 2006 has been rejected by the local authorities. Why the petitions were rejected? They had failed to furnish evidence to substantiate the claims of their stay inside the forest. Expressing concerns over such decisions, experts have said that in a country where maintaining records of evidence and documents were a recent phenomena, accepting tribals to provide records to substantiate claims that they lived inside the forest before their eviction in 1972 was ridiculous and was in contravention of the concept of natural justice. About the Forest Rights Act. The Act passed in 2006 grants legal recognition to the rights of traditional forest-dwelling communities. Rights under the Acts. Title rights, that means ownership, to land that is being formed by tribals or forest dwellers as on 13th December 2005, subject to a maximum of 4 hectares. Ownership is only for land that is actually being cultivated by the concerned family as on that date, meaning that no new lands are granted. Use rights to minor forest produce, to grazing areas, to pastoralist routes, etc. Relief and development rights to rehabilitation in case of illegal eviction or forced displacement, and to basic amenities subject to restrictions for forest protection. Forest management rights to protect foresters and wildlife. Eligibility criteria. According to Section 2 of Forest Rights Act, to qualify as forest dwelling scheduled tribe and be eligible for recognition of rights under FRA, 3 conditions must be satisfied by the applicants who could be members or community. First one, must be scheduled tribe in the area where the right is claimed, and 2, primarily reside in forest or foresters land prior to 13/12/2005, and third one, depend on the forest or foresters land for bona fide livelihood needs. and to qualify as other traditional forest dweller and be eligible for recognition of rights under FRA, two conditions need to be fulfilled. First one, primarily resided in forest or forester's land for 3 generations prior to 13/12/2005. Second one, depend on the forest or forester's land for bona fide livelihood needs. Critical wildlife habitats. They are defined under the Forest Rights Act 2006 as the areas of national parks and sanctuaries where it has been specifically and clearly established, case by case, on the basis of scientific and objective criteria, that such areas are required to be kept as inviolate for the purposes of wildlife conservation. Eighth one, Jammu and Kashmir Development Act. The Centre has notified new landas for the Jammu and Kashmir UT region, ending the exclusive rights enjoyed by the local population over land under the now diluted Article 370. Who introduced the changes? The introduction of the UT and Jammu and Kashmir Reorganization, 3rd Order 2020, by the Ministry of Home Affairs has resulted in the repeal of at least 11 landas in vogue in Jammu and Kashmir earlier, including the Jammu and Kashmir Big Landed Estates Abolition Act that had resulted in the famous land to tiller rights. What are the latest changes? Under the newly introduced Jammu and Kashmir Development Act, the term being permanent resident of the state as a criteria has been omitted, paving the way for investors outside Jammu and Kashmir to invest in the UT. No land used for agriculture purposes shall be used for any non-agriculture purposes except with the permission of the district collector. The government may now allow transfer of land in favor of a person or an institution for the purpose of promotion of healthcare or senior secondary or higher or specialized education in Jammu and Kashmir. Also, no sale, gift, exchange or mortgage of the land shall be valid in favor of a person who is not an agriculturist. An army officer not below the rank of corps commander can declare an area as a strategic area within a local area only for direct operational and training requirements of the armed forces. Implications. People, including investors outside Jammu and Kashmir, can now purchase land in the Union Territory. Ninth one, Consumer Protection Act 2019. The Consumer Protection Act 2019 was notified on August 9, 2019. New provisions under Consumer Protection Act 2019, inclusion of e-commerce, direct selling establishment of Central Consumer Protection Authority, strict norms of misleading advertisements, strict norms for product liability, changes in the pecuniary jurisdiction, greater ease to dispute resolution, addition in the class of unfair trade practice, unfair contract, alternate dispute resolution through mediation. Who is a consumer? A person who buys any goods or services for a consideration which has been paid or promised or partly paid and partly promised or under any system of deferred payment also includes the user with approval of such goods or beneficiary of services. As Person Consumer Protection Act 2019, the expressions buys any goods and hides or avails any services includes offline or online transactions through electronic means or by the teleshopping or direct selling or multi-level marketing. Who is not a consumer? A person who obtains goods free of charge, who avails services free of charge, who obtains goods or resale or for any commercial purposes, who avails services for any commercial purposes, who avails service under contract of service. As per the provisions of the Act, commercial purposes does not include use by a person of goods brought and used by him exclusively for the purposes of earning his livelihood by means of self-employment. What consumers' rights are guaranteed under Consumer Protection Act 2019? Consumer is having the following 6 consumer rights under the Act: right to safety, right to be informed, right to choose, right to be heard, right to seek re-addressable, right to consumer awareness. Who can make complaint? A consumer or any voluntary consumer association registered under any law for the time being in force, or the central government or any state government, or the central authority, or one or more consumers where there are numerous consumers having the same interest, or in case of death of a consumer, his illegal heir or legal representative, or in case of a consumer being a minor, his parents or legal guardian. Can a person buying goods or hiring services for business purpose make a complaint? No. What are consumer disputes re-addressal agencies? These are quasi-judicial bodies established under the Act to provide simple, speedy and inexpensive re-addressal to the grievance of the consumers. These have been established at 3 levels: district, state and national, known as District Consumer Disputes Re-Addressal Commission or District Commission, State Consumer Disputes Re-Addressal Commission or State Commission, National Consumer Disputes Re-Addressal Commission or National Commission. What is the pecuniary jurisdiction of commissions? District commissions up to 1 crore, state commissions 1 crore to 10 crores, national commission above 10 crores. What is a misleading advertisement? Misleading advertisement in relation to any product or service means an advertisement which falsely describes such product or services, or gives a false guarantee to, or is likely to mislead the consumers as to the nature, substance, quantitative or quality of such product or service, or conveys an express or impelled representation which, if made by the manufacturer or seller or service provider thereof, would constitute an unfair trade practice or deliberately conceals important information. Who all can be made liable for a misleading advertisement? Manufacturers, advertising agencies, celebrity endorsers, and publishers can be made liable. What is CCPA? The new act provides power to central government to establish Central Consumer Protection Authority to regulate matters relating to violation of rights of consumers, unfair trade practices and false or misleading advertisements, which are prejudicial to the interest of public and consumer, and to promote, protect and enforce the rights of a consumer or a class. The central authority may inquire or cause an inquiry or investigation to be made into violations of consumer rights, either suo motu or on a complaint received or on the directions from the central government. 10th one, 2020 Indian Agriculture Acts. The Indian Agriculture Acts of 2020, often referred to as the Farm Bills. Supreme Court stayed the implementation of the Farm Laws and appointed a committee to look into farmer grievances related to the Farm Laws. Their stay on their implementation means the central cannot, for the time being, proceed with any executive actions to enforce the laws. The Punjab, Rajasthan and Chhattisgarh state assemblies tabled bills to counter and amend the centre's 3 farm laws. Farmers Produce Trade and Commerce Act 2020. Prior to the 2020 legislation, agricultural trade in India could only be conducted in APMC. This act, however, allows trading in outside and trade areas such as farm gates, factory premises, warehouses, cold storages, and prohibits state governments from levying any market fee on farmers, traders, and electronic trading platforms for trading the produce of farmers in such areas. The Act seeks to facilitate lucrative prices for farmers through competitive alternative trading channels to promote barrier-free interstate and intrastate trade of agricultural goods. It also permits the electronic trading of farmers' produce in the specified trade area, facilitating direct and online buying and selling of such products through electronic devices and internet. Farmers' Agreement on Price Assurance and Farm Service Act 2020. The government asserts that the Act helps protect farmers engaging with agribusiness, farms, processors, wholesalers, exporters, or large retailers for farm service and sale of future farming produce by a mutually lucrative price framework fairly and transparently through a contract. The Act provided for a three-level dispute settlement mechanism by the Conciliation Board, Subdivisional Magistrate, and Appellate Authority. The agreement had to provide for a conciliation board as well as a conciliation process for the settlement of disputes. Essential Commodities Act 2020. The ECA was enacted in 1955 and has since been used by the government to regulate the production, supply and the distribution of a whole host of commodities that it declares essential to make them available to consumers at fair prices. Additionally, the government can also fix the minimum support price of any packaged product that it declares an essential commodity. The list of items under the Act includes drugs, fertilizers, pulses and edible oils, as well as petroleum and petroleum products. The Center can include new commodities as and when the need arises and take them off the list once the situation improves. With Essential Commodities Act 2020, the stock limit will be imposed only under exceptional circumstances such as famine or other calamities. There will be no stock limit for processors and supply chain owners based on their capacity and for exporters based on the export demand. It would also end some punitive measures. It will also deregulate agriculture produce such as pulses, onion, potato and cereals, edible oils and oil seeds to realize better prices for farmers. Thank you. Please like, share, comment and subscribe. Thank you.